Hi, everybody. Welcome to our Enforcement Strategies AB 130 update. My name is Lori Poole. I am a co-managing partner at Davis-Stirling.
And hello, everyone. I'm Rob Ward. I was with Lori on the last webinar we did. I am a partner here at Davis-Stirling in charge of the Orange County division.
All right, so let's talk about why we're doing this update. For those of you who watched our webinar on enforcement strategies, what to know and what to avoid, that we aired on June 24th, 2025, you'll remember that we talked about a bill that was in the legislature that might have an impact on the way associations can enforce and impose fines. Well, we thought we weren't going to have to talk about this bill at all, or the legislation at all, or not until January 1 of 2025. Something happened earlier this week on June 30th, 2025, that surprised us all and created the need for us to do this update so that we can update all of you as to how this new law affects associations and their ability to enforce violations of the governing documents. So, Rob, you serve on the LSC for the Legislative Support Committee for CAI San Diego. What happened?
Yeah, I do serve on that committee. And the interesting thing is that over the last several months, when a bill called SB 681 was introduced, our Legislative Action Committee was actively opposing that bill. And what that bill was basically a larger version of what AB 130 has now enacted, and that was to limit the amounts of fines that you can enforce for violations of the CCNRs. How did this happen? Well, you can't take your eyes off of the people in Sacramento for very long before things like this happen, and there's always some legislative sausage making going on. Senator Wahab, like we said, authored this bill, SB 681, and she was trying to eliminate what she calls the onerous fine practices of community associations. Onerous fine practices, which is interesting language. We saw that in the legislative notes on this. She wanted to limit fines for violation of the CIDs to $100, sort of a one-size-fits-all approach. There was a whole lot of pushback from our organization on this. We met with state legislators in Sacramento about it. We told them why this was such a bad idea, that the one-size-fits-all fining approach, limiting to $100 per violation, simply would not work, and gave specific examples of why it wouldn't work. Well, this bill has been amended back in May and kind of sat in committee for a few months, and it looked like it was going to go nowhere. So what happened? Well, Senator Wahab worked with a few other legislators and had their eye on AB 130, which is the budget bill, a big giant budget bill, which you know was going to be passed because California needs its budget passed. And she was able to, in some sort of backroom deal, slip the language from 681 with some amendments into AB 130. And now, as a result, this bill, basically over a weekend, it took about 5 days for this to transpire. There was no discussion, there was no debate. This language was simply slipped into the bill as a rider. And the bill, as Lori mentioned, was signed by the governor on June 30th. And now it's law. It goes into effect immediately. It was an urgency bill because it is the budget bill. And we think it's going to be around for a while until it goes through some modicum of interpretation by the courts, or perhaps even some sort of amendment process. The other thing I wanted to mention was that SB 681, which was the bill that started all of this, is still around. It's sitting in committee, and we don't know what's going to happen with that. It could be that that bill dies, but the result of it, though, now is that AB 130 has changed the law for us, and we're going to talk to you about how those changes will affect you, your boards, and if you're managers, the boards that you are agents for.
Yeah, and we should introduce ourselves. So I am Lori Poole with Davis-Stirling. I am a co-managing partner of the firm. And Rob?
Yes, and I'm Rob Ward. I'm one of the partners here in charge of the Orange County division of our firm. And as we mentioned, a lot of the members of our firm do work with the Legislative Action Committee for CAI. And so we're all very aware of this, and we're ready to advise our clients on how to negotiate through this limitation on fines. Let's talk a little bit about what that means.
Yeah. So I'm going to preface the rest of our update here with I've really been into the Jaws 50th anniversary, and I rewatched the movie a few weekends ago, so you may see a little bit of a theme here. So just when you thought it was safe to impose fines, what happened? AB 130 was enacted, like Rob indicated. Just happened on Monday, June 30th. It became effective immediately.
Yeah, and
So,
every one of us, when we saw this bill was enacted, looked just like Roy Scheider looks right there in that picture. We were
yep.
shocked.
And if you remember, I do remember because I just rewatched the movie. This is where we see the shark for the first time, and Roy Scheider pops up, and that's the look on his face. Um, so it became effective on June 30th, like we said. So it is effective now. It is good law now. We don't know what's going to happen. Associations really do need to uh, act, understand that this is the law now until something else happens, which may never happen, which may happen at some point. So now it amended two provisions of the Davis-Stirling Act, Civil Code Sections 5850 and Civil Code Section 5855. 5850 is the section that talks about fine schedules and having to have a fine schedule if you're going to impose monetary penalties, and providing a copy of the fine schedule each year as part of the annual disclosures. 5855 is the section that talked about disciplinary hearings, the time period in which you need to provide notice to an owner before imposing disciplinary action, which is not just fines. It could be suspension of monetary of right to use the amenities, like we talked about in our prior enforcement webinar. So 5855, the changes there are broader than just on fines. It applies to any discipline that's going to be imposed on an owner. So let's dive into this a little bit more. So probably the most shocking, I guess, part of the bill is the limit on fines. And this is the change to Civil Code Section 5850. What the new law says is that there is a $100 per violation limit on the amount of fines that associations can impose. And actually, what the new statute says, it's the lesser of what the governing documents say, or $100. So if an association's governing documents have fines that are higher than $100, you can only impose up to $100. If the association's fine schedule has less than $100, if you haven't amended your fine schedule since, I don't know, 1980 something, and you still have $25 fines or $50 fines, then you can only impose that lower amount until you amend your fine schedule, your enforcement policy, to bring it up to the $100 level. So that is one impact of this new bill. Now, there is an exception, which Rob is going to talk about. There is one exception where higher fines can be imposed.
That's right. There's always an exception to the rule, and if you practice law long enough, you know that there's going to be something added to appease somebody else to include as an exception, and this is no different. Before I mention this, I should say that if you do go and read AB 130, it is a giant bill. It's a behemoth bill. It's the budget bill. And so it's going to be hard to find the language that applies to community associations, but it's there. And so we always encourage people to read the actual fine print. But one of the things in that fine print that was added really late in the process, apparently right before this bill was passed, was this exception. And the exception says that it's meant to soften the blow to community associations, I suppose. But higher monetary penalties, if you think that you can't at all impose them, that's not true. You can actually impose a higher monetary fine than $100, but only if the violation may result in what they're calling an adverse health or safety impact on what? On the common area or on another association member's property. So focus on that. We're talking about whether the adverse effect is to the common area itself or to any other member's property. That does not mean that the adverse effect is on another member themselves. It's only on the property. Before, however, you impose that higher monetary penalty, under this exception, the board has to make a written finding that specifies what that adverse health or safety impact is in an open board meeting. So associations are still going to need to have a fine schedule for these types of violations, and you're going to have that open meeting. And if you're going to use the exception, you need to specifically state what that adverse impact is going to be on the common area. Again, it's either on the common area or another member's property. It doesn't include adverse impacts on other members. Now, what does that mean? Does that mean that smoking violations have adverse impacts? It's possible. It is possible if it can be shown that the smoke is causing damage to the common area in some way, or the property itself in another member's separate interest. But how is that going to work? Is it smoke damage? It's not based on the health of the member. It's based on what property is being affected adversely. We're going to have to analyze this on a case-by-case basis because there are a lot of different possibilities here. And I suspect, this is, like we said before, this is going to keep lawyers busy. We're probably going to end up in court on this, and judges and arbitrators are going to start interpreting what this means until we get some clarity on how this language is going to be interpreted. But that's the exception, the adverse impact exception.
Yeah, and I kind of want to touch on a couple things more about the $100 fine limitation. One of the questions we are getting a lot is, what about recurring fines or daily fines? And we did talk about this last week. Last week before we knew this was going to happen, we did talk, advocate against daily fines. We did have concerns that uh, that judges would find that, excessive fine amounts would not be reasonable. So in light of the stated legislative intent of this bill was to prevent onerous fining, fee practices imposed by HOAs on members, I think associations are going to have to take that into consideration in determining how, whether they could impose recurring fines, $100 fines recurring for certain violations that are continuing. The statute does not define what violation is. So it's $100 per violation. It does not define what a violation is. So association could certainly work with legal counsel in coming up with a definition, but we would caution against definitions that would be against what the legislative intent was, which was to stop onerous fining fee practices. So things like that. So now, if a homeowner has loud parties, let's say 5 nights outside of quiet hours in a 2-week period of time, I do think each one of those instances is a separate violation that where $100 could be imposed on each different instance of that type of nuisance activity. But I think you're gonna see the questions more with maybe unauthorized architectural modifications or things like that that are continuing in nature, failing to maintain their property or something like that. That's a continuing violation. Short-term rental violations, we see that as well. Or these are where I think this question of what does the $100 per violation mean? And it's going to be open to a lot of interpretation by different attorneys in the industry, but associations should work with their legal.
Okay, and yeah, you recall that in our last webinar, the whole point of the enforcement policy talk we gave was to ensure compliance. And so what they're doing here with this bill is making it a little bit more difficult to ensure compliance, especially with respect to things like short-term rentals, which, let's face it, if somebody's in violation of the short-term rental laws and agreements, they're making a lot of money that way. And $100 fine is simply not going to deter that. So this is something that we're really going to have to consider, and attorneys are going to talk about this going forward. And if you go to the next slide.
Um, yeah, I was just going to touch on one point there, which is, what we did talk about last week is that if fining doesn't work, then associations are going to have to step up enforcement. I didn't think that they'd have to step it up quite so quickly, but I do think that's going to be in effect. I do think that um, associations, after if $100 fine isn't gaining compliance, are going to have to involve legal counsel sooner than they otherwise might have with, say, a higher fine schedule for like a short-term rental violation. So so we'll go on to the next slide because there's one last part of 5850 that was amended by AB 130.
Yes, and that's right. And you can see our friend here objects to it as well as we do. But these changes to the civil code have specifically also carved out late charge fees or interest on these fines for non-payment. You cannot charge late fees or interest now for the non-payment violations. This is just adding insult to injury, and you can see how our friend here, Jaws, feels about that. We believe it to be the same way.
Trivia question: do you know it was a mechanical shark in Jaws? Do you know what the nickname was for the mechanical shark in Jaws?
Oh, I don't know, but this has already given me the creeps because
It
this
was Bruce.
this gave me really bad nightmares when I was 6 years old.
It was Bruce. The name of the
Bruce.
mechanical
Oh,
shark
right.
in that they used in Jaws was Bruce. So yeah, so there's no late fees or interest. I don't know how many associations were actually charging late fees and interest on fines that weren't paid, but to the extent associations were imposing late fees and interest, we can't do that. This is a really good point to a really good reminder too, that this is regarding monetary penalties, fines. Reimbursement assessments for costs incurred by the association in gaining compliance is completely different. It is not considered a monetary penalty or a fine. It is an actual cost that is incurred by the association for certain things. Gaining compliance with the governing documents may be one of them. So we want to make sure that the enforcement policies, the fine schedule is very clear that monetary penalties and reimbursement assessments are separate and distinct.
Yeah, and
All right.
something that Senator Wahab was really interested in was also the idea that violators or alleged violators should be given the right to cure what they have done, which really was always the case. When you sent out a notice letter, they always had the opportunity to cure the violation before the hearing. But Lori will talk a little bit about these new enforcement procedures and what that means.
Yeah. So, like Rob said, the before the meeting where the owner is being called in for discipline, and again, this is now these are the changes to Section 5855, and this is broader than just the monetary penalties. This is any type of disciplinary action that an association is going to impose on a homeowner. So before the meeting, the owner is going to have to be given the opportunity to cure. Um, I do think that the hearing notice letter will need to include that to let the owner know that if they cure the violation before the meeting, that the association will not be imposing discipline. It also says that the statute says that the association cannot impose discipline if the owner makes a financial commitment to cure the violation. Huh? What
What
does
does
that
that
mean?
mean?
Yeah, that language is certainly causing those of us in the industry, the attorneys, to scratch our heads and try to picture scenarios in which an owner could make a financial commitment that could stave off disciplinary action. This is specific to where the violation cannot be cured within the time period between the notice of the hearing and the actual hearing. Then the owner can make a financial commitment to that would to cure the violation. The the examples that come to my mind are things like maybe failing to maintain something on their property that they need to maintain. They've been notified, they need to fix it, they haven't done it, and they probably might not be able to do it within the time period between getting the hearing notice and the hearing.
Yeah, one
Um,
example I've noticed over the years is I've had instances where architectural violations have been reported, and the owner or yeah, the owner of the unit had altered the structural nature of the unit in some way, and in a substantial way, without getting permits and things. And so, what is the financial commitment going to be for them to cure? Is that going to be signing a contract with a contractor? Is that going to be placing a deposit down to get the work done? We don't really know right now. Financial commitment is just one of those terms that is going to require some interpretation.
Yeah, and is it just the owner saying, "Okay, I commit to to financially fund curing the violation"? They can say that, but what if it doesn't happen? So a lot of questions as to that language, the new language in 58, 55. I also think things like if they painted their house the wrong color or a portion of the house the wrong color, yeah, is it that they've entered into a contract with somebody to repaint or something like that could be
Yeah.
evidence of a financial commitment.
Or do they need to
Again,
produce an invoice that they bought the paint that they're going to use to correct the, we don't know.
yeah, yeah. Again, this is going to need to be analyzed on a case by case basis um, and being creative. So the new enforcement procedures also talk about if after the hearing, if there's an agreement with the owner and the association, then the board has to draft a resolution that if it is signed by both the board and the member, it is judicially enforceable. And the statute says it's judicially enforceable to the association. I would also say that it would be judicially enforceable against the owner as well, but that's not specifically stated in the statute. But they're looking, I think, for the board and the owner at the hearing to come to some kind of an agreement that would then be reduced to writing. It's not too dissimilar from, I guess, the concept in IDR hearings, that IDR meetings, that if there's an agreement reached and it's in writing, then it's judicially enforceable. If the owner and the association do not reach an agreement during the hearing, then they need to be informed that they have the opportunity to engage in IDR. So I think the hearing results letter is going to have to be modified to include that language if there was no agreement reached, to notify owners that they have the opportunity to engage in internal dispute resolution. So another change, and uh, not sure why this happened, but another change was that they changed the time period in which the association has to provide the hearing results to the member after the board has made a decision to impose discipline. It was 15 days, now it's 14 days. So I don't know. Again, I don't know how many associations waited to the 15th day. I know there were times where I was looking at things and it was literally the 15th day, and I would advise the client, you need to get this letter out today. So just everybody needs to be aware that that time period is shortened by 1 day.
I don't know. Maybe they were just looking forward to having 2 weeks versus this 15-day period, which I don't know what the 1 day matters for, but keep that in mind that you got one less day to provide those hearing results.
Okay, so what are our recommendations?
We do have some recommendations, and
Do
it
we need a bigger boat?
doesn't necessarily mean you're going to need a bigger boat, but what you are going to need is to review your fine schedule and revise that schedule to comply with these new laws. You can't have fines over $100 in your fine schedule anymore unless, as we mentioned, that exception applies. And you're going to want to review and revise your enforcement procedures as well. And what are we going to do? We're going to include the members' hearing rights provision to that Lori just discussed, that was so important, that it didn't matter that we could send a notice out and allow them to cure anyway. Let's make sure that the members' curing rights provision is included in your enforcement procedures. We want to include that IDR option as well that Lori just talked about, and all the written resolution procedures. And we also want to make sure that you include in that in those enforcement procedures the new time frame for notifying members of the disciplinary action and the monetary penalties imposed. All of this should be in your compliance and enforcement procedure paraphernalia.
Yeah, and to be clear, the statute isn't requiring that enforcement policies get and fine schedules get updated. It's not requiring that because it does say that as far as the fine amount, it's the lesser of either $100 or what's stated. But we are recommending that associations revise their fine schedule and their enforcement procedures because it's going to eliminate a lot of confusion if you have fine schedules with higher amounts than $100 for non-adverse fines. The other thing too is, as we indicated, is for those situations where there is an adverse impact on the common area or another member's property, you do have to have a fine schedule for that. So I do think that the fine schedules should be specific, that this is the fine schedule for those types of violations. And without that language, without amending your fine schedules or without adopting new enforcement policies and fine schedules, there's always going to be a question as to whether the higher fines will apply.
And ultimately, keep in mind that this is included in the bill, that fines have to be reasonable no matter what. Whether that's $100 or whether the adverse impact exception applies, keep in mind that you still can't impose an unreasonable fine for whatever violation you're talking about.
Now, some of the other questions we've received is boards that maybe met last week and imposed a fine of higher than $100. Are they still allowed to impose that fine? The bill became effective on June 30th, Monday. So I do think if associations imposed higher fines in the last few weeks and have sent the hearing results letter with the higher fine amount, I do think that associations are going to still be allowed to collect that. However, if an association met and has not sent out the letter yet with the fine amount, out of an abundance of caution, those associations may want to consider reducing the amount to $100. That's kind of up in the air. It was imposed under a before this law changed. There is an argument you can continue to collect that higher fine amount. But if the letter hasn't been sent yet, you should certainly check with your legal counsel and see what your legal counsel advises. And I do think you're going to need a bigger boat. And I think the bigger boat, it may be like we talked about, fining has lost a lot of effectiveness that it had prior to Monday. So when the fining doesn't work, you are going to have to step up the enforcement and get probably the first step is to get the attorneys involved to write violation letters. And again, that discussion of reimbursement assessments are different than monetary penalties. The association can start imposing the reimbursement assessment for the cost to get the lawyers involved in gaining compliance.
Yeah, there's going to be a lot of interpretation done going forward, and so this is sort of an evolving scenario for us, and it will be for you as well. But please don't hesitate to consult with your legal counsel to get an opinion on whether you can impose higher fines and an adverse impact type of exception, or if you have any confusion as to how this is going to be applied going forward.
Yeah. All right, well, that's it. And we hope you enjoyed the update. You certainly reach out to us if you have additional questions. And another recommendation is to rewatch Jaws if you haven't seen it lately. I really enjoyed seeing it again. It is being released again I believe it's being released out in the theaters either this month or next month as part of the 50th anniversary of the original release of Jaws. So
watch out for sharks this summer.
And stay safe.